Good afternoon and welcome to episode 85 of Cannabis Live. I'm Jennifer Domingue with Cannabis Legal Group, and I'm joined today by one of our Counsel attorneys, Salam, Elia, who helps us draft a lot of our transactional documents. She's very experienced with business matters, real estate matters. She's even represented multiple municipalities, so we're very fortunate to have her join us on the show today to talk about how to structure your cannabis business entity, as well as the real estate considerations you want to make. But before we get into all of that, let's talk about the news. So this past week, we actually had the February Medical Marijuana Licensing Board meeting, where we got a few snippets of additional information and insight on how the board is treating some of these applications. There was one interesting part that was raised as a new reason for denial, one that we really hadn't seen before, and it was an operating agreement that had been submitted in an application packet that allowed for free transferability of the membership interest without requiring board approval. And to allow free transferability of the membership interest without requiring a new owner to go through the board approval process is simply not allowed. And so that was something that they debated as part of a reason for denial, which we found to be very interesting. Another key takeaway from the licensing board meeting is that there was our first ever change in ownership approval. So there was a successful business entity who sought to change ownership. I believe it was a transfer of 25% of the business entity membership interest that was successfully transferred. And there wasn't much discussion about that process or what the board was thinking, but it certainly is a strong sign for these transfer of ownership opportunities in the future, and something that we will probably see much more of, as well as probably get a little bit more insight as the board becomes more familiar with this aspect. Finally, just part of the department's monthly meeting, they always give a department update as to what the status is of these applications. So far, there have been 1,022 step ones that have been submitted and paid. 294 have been approved, 125 have been denied, and 94 are considered inactive for lack of movement by the applicant's part. Briefly, the Class A's, there was 41 submitted and 3 approved, 2 denied. Class B, there was 6 submitted, 1 approved, 0 denied. Class C, there was 234 submitted, 38 approved, and 4 denied. Processors had 67 submitted and 11 approved, but none were denied. Provisioning centers had 229, with 59 of them approved and 35 denied. Secured transporters and safety compliance facilities also had applications that were submitted. There was 5 secured transporters that were approved and 4 safety compliance facilities that were approved, and neither of those categories had any denials. So now that we have kind of had a good idea of what the board is looking for in structuring or looking at their application process, it's really important to think critically, not just how are you going to structure your business to meet the board's approval requirements, but also how are you going to structure your business to have continued success and basically give a foundation for what this business is going to look like moving past licensure. So that's why I've brought our transactional business attorney, Counsel attorney, to the table to kind of discuss the importance of a corporate governance structure. Salam, how important is it to have the foundation, an operating agreement? Can you talk a little bit about the real necessity of these documents for a business?
Yeah, so thank you for having me. I'm glad to be here with everybody today. And the first thing that we notice is what is an operating agreement? Mm-hmm. You know, many people don't even know what that term is. It's an afterthought. And so that's kind of a good and bad sign in a way, because the transactional side should always be an afterthought. You should have the papers in place, usually by a very sophisticated legal team, and especially given the fact that now the marijuana industry is new. It hasn't been around. Okay. So we are pioneering the industry. People have always known that there are companies. It's just how do you make the company run in a certain way to comply with the existing laws that are constantly changing. Mm-hmm. And I mean, the numbers that we had before from how many businesses were licensed till now has substantially grown. Right. So what we're now trying to figure out is what is the best way to structure the type of company that you have. So it really depends on the type of business that you have. So when we have clients coming to us and saying that, I own certain property and I want to lease it to somebody who is trying to get into the cannabis industry. Or if we have clients who want several different licenses, some for processing, some for growing, some for dispensary. Each type of business is unique to what they want to build and establish, and it's important that you tell your attorneys and you educate them about what you want to do so that we can help you build a strong foundation for that business now and for in the future. So there are really two types of companies that we see often now, which are corporations. When you see it has an Inc., like INC, or you see LLCs. Limited liability companies. These are the most frequent ones that you see often now because they're the most newly developed type of entity. They all were not created at the same time and they're all not equal. As the industry involved, people wanted to be protected more for the things that their companies did. They have separate identities. And so the Limited Liability Act is the latest type of corporation which provides the most protection that we've seen for business owners. And so the vehicle by which sets the rules, procedures, the do's and the don'ts is called the operating agreement.
Okay, so let me ask you this. If we decide that we want to have a marijuana business, do I have to create an LLC or an Inc., or can I just be like a sole proprietorship and just hang my shingle outside and say, I have a license now and I don't need to have a formal business entity? Is that something I can just get away without doing, or would you really suggest I create an LLC or a corporation?
It's something you can definitely do to get away with, but something that realistically wouldn't allow you to do anything other than just have it. People want to be able to sell their business, to grow their business, to bring people into their business. So it's kind of like doing business in the Stone Age, if that's the way that you're going to do it. And also, especially in the marijuana industry, because it's not yet approved by the federal government, and it does have, like any other business, liabilities that carry on with it. We want to be able to protect you and shield you from a lot of corporate liability. Not to say if you do something wrong, it's not going to come back at you, but it's just another layer of protection for things that you may be doing in the normal course of running the business. So once we figure out which type of business that you want to do, we will then figure out if you're going to do an LLC or a corporation. So you can't have it in your name. It has to be in a company name.
I think that's smart. And, sometimes there is the best of both worlds. So, for instance, to protect somebody, she was talking about having limited liability to protect a person's assets and to protect them from, shield them from any sort of civil litigation or lawsuit that's filed against you. There's also tax considerations to have when you're thinking about what form of business entity you want to have. If you have an LLC, you're going to have what's called pass-through taxation, meaning that whatever money the company makes, it's going to go to you as profits and you're going to have to claim it on your taxes. So it's just very simply, there's only one level of taxation, and that's on you as the member of the LLC. On the flip side, you have corporations who now have what's commonly referred to as a double tax, meaning that the company takes in income because they're generating money, and they will be taxed on that profit that they're making, profit or loss. So they're going to be taxed on that. And then when they make a distribution to the shareholders or the owners, then the shareholders / owners are then taxed on that distribution. So we have a concern where, well, why would I ever go with a corporation if I'm going to be taxed twice on that money when I could go with an LLC? And that's something that you really want to talk about with your transactional business planning attorney. You also want to talk about it with a CPA because it means different things for different businesses. But the main reason that we suggest even an LLC taxed as a C corporation, that's an option, is that if the IRS were to audit your business and you're taxed as a C corporation, then that audit would stop at the entity level rather than going directly to you, the individual, as well. So to protect against a really intensive and intrusive, time-consuming audit that is going to encompass not only the business's finances, but also your personal finances, it's worth it to some clients who want to incur that additional taxation just for that additional protection. So that's something that you want to definitely consider and have a conversation with your attorney, your CPA, your bookkeeper, your team behind the scenes, if you will, of how you're going to structure this business. So an LLC is an incredibly fluid business vehicle. You can modify it. There's a lot that you can do with an LLC, and you can even have it taxed as a C corporation. So you can do a lot of different things with an LLC. A corporation's a little bit more rigid, correct?
Yeah, and I just want to take the opportunity to clarify one misconception that I think we get all the time. Whenever we sit down with a client and we say, we're going to form you a company, the first thing they say, oh, form me an S Corp. A lot of people think that the way that the company is taxed is the vehicle by which we're going to file. So an LLC or an Inc., which we call corporation, both can be taxed the same way. But the way that I like to look at it and explain to clients in some situations is think about if you have the old iPhone and you have the new updated iPhone, which one do you want? You want the new updated one. So that's why you need a team of professionals, because especially with the marijuana industry, there's a lot of things that you can be taxed for that wouldn't apply to other situations. So we have more tools in our toolbox to help identify which is the best way to structure your company. But it's a conversation that needs to be had.
Right. So there's a couple of tools that you're going to need when you're creating this business, not just because the state requires it for their application, but also because it's going to help create the rules by which your company exists. So an operating agreement, bylaws, an authorizing resolution. I'm using words that might sound like Greek to you right now, but an operating agreement, that's just basically the rules of the company, right, for an LLC?
So the interesting part about it is there's already a law that created the ability for you to have the limited liability company, the LLC or a corporation. And in that law, it says, here are the basic rules. So if you don't end up hiring a team of attorneys or anybody to prepare your own agreements, guess what? It's not that you don't have agreements. It's that whatever the law says the rules are, those become the terms by which you live by. Mm-hmm. So if you have, again, the option of creating somewhat your own rules that fit your needs, or what the state says your rules are, which one are you going to pick? And that goes back to having best of both worlds. So we're going to follow the law and tailor it to what your business needs are based on your individualized relationship, and we'll create the operating agreements or whatever the corporate documents that we need in order to be the vehicle by which you do business.
So what sorts of things can we modify in an operating agreement that would be slightly different maybe from what the state would want? Is that like if I wanted to wind up my business or sell my interest? Like what sort of things can I change in an operating agreement?
Well, the most important thing that, the things that I would say are, one is how are decisions going to be made? Because say it's you and I, of course, we're never going to disagree, so we're not going to have any problems. But say we have more people in the mix. And if we want to do something, how do we make a decision? Because it's not Salam moving on her own or Jennifer moving on her own. It's how does the company do this? And so you need to be able to put the rules in place on how to do it. So you need to decide, is each person that's in the company, do they have a voice? Can they vote? Or is it based on percentages? And based on percentages, is that going to determine how much ownership interest each person has? Like if I put in $100,000, should I own most of the percentages in the company, or should I have less? So these are considerations that you want to be able to address in the operating agreement. One vote per person, or is it based on percentage? Another reason is if I want to sell or get out of it. You know, I want to go to Bora Bora and retire, and I'm done with this right now. And if I want to leave and I want to sell my shares, how do I get out? If you do not establish the procedures on how you can sell your shares or get out of the company and at what price you have to be paid for those shares, you're leaving it to people you don't know, that don't know your industry, that don't know your business, that don't know what's going on, to tell you what your value is worth. So why do that, right? Who knows better than you on what you're worth?
Absolutely. So I think that it's pretty clear that you definitely want to take some time to really think about what your specific business structure is going to look like and what is going to help guide your business, not just now, but in the future. People can print off a sample operating agreement from the internet and fill in the blanks and submit it to the state for their license, and they didn't even read it. They don't even know what it means, or it might not even apply to what a marijuana business could need. I think that the example from in the news earlier is an excellent example of that, where somebody submitted an operating agreement and they didn't read about the transfer of membership, or they didn't realize that that's prohibited, and they just submitted an operating agreement without saying that it's actually a restricted ability to transfer membership interest. You need to have the board approve it before they can transfer.
Absolutely.
So we really want to make sure that if you're having a lawyer look at or create an operating agreement for you, or you're making your own, you want to make sure that you tailor it specifically to the industry, to your business, and to the state marijuana laws as well.
Yeah, especially with that in mind. It's shocking because say the board approved it and it went through without the restriction that you have to be approved by the state in order to be a member in that company, an owner in that company. Well, what if I want to bring my brother in the company, okay? So I sell the shares according to everything that's in the operating agreement. He's now on paper in here. Right. Doesn't that mean that the whole company now violated the rules because we've now brought somebody in?
Absolutely.
That's not licensed by the state, and we just jeopardized our entire license?
That's exactly it. So that's how huge the ramifications can be in a situation like this. There's also other corporate documents that you are probably going to want to consider to help build out that foundation to your business. They're ancillary, they're not quite as integral as an operating agreement, which is truly the backbone of your business. But there's things that you're going to want to talk to a transactional attorney about, like your employee handbook. If you have standard operating procedures that you need to have outlined for your employees, you might want to have employment agreement contracts already pre-written, or vendor contracts that you have already vetted by a business attorney ready to go that will be suitable for this industry. So these are all foundational transactional documents that will help you structure your business so that you're ready to have a successful future once you have your license.
Yep, and I think it's important to note that because we're in the beginning stage of figuring out how to structure your company and what works best for you, we're asking all these questions. We're trying to figure everything out. But then once they're established, you have your procedures. These things become an afterthought. The operating, every time you go and you talk to your employee, you're not going to pull out your handbook and say, well, what am I supposed to say? What am I supposed to do? Right. It's a reference for you to be able to look at in case you're stuck somewhere or you're not there anymore. It's the same thing with your corporate documents. It's not something that it's going to be an afterthought, because you're supposed to be doing what you already agreed to do in the beginning.
Right, absolutely. So moving past the operating agreements, I have my business formed, I have the foundation laid, and now I have to figure out where I'm going to be. The real estate considerations here. Should I own my parcel of property? Should I own the location, or should I lease it? If I'm owning it, should I put it in my own name? Should I put it in the business name? Should I have it in a holding company? And what does that look like? So, Salam, I know that you've helped me with leases in the past, and if you are leasing a property for marijuana, I know that it's required that the state submits, the state receives a disclosure saying that the landlord consents to the use as marijuana, a marijuana-related business. But what sort of considerations would you have when you're talking to somebody about what the lease structure would look like for their marijuana business?
Right. It's actually a very, I'm glad that you brought this up because it goes on both sides. First, there's specific considerations that a landlord has versus what a tenant has. If the landlord is putting you in a plaza where they have loans on it, federal loans, they have to be very careful first in that, remember, this is still not 100% legal under the federal law. And so if they're allowing a tenant to come in there and operate this type of business, and if they do have federal loans out there, it's a consideration that they have to make sure they're not violating their own loan. And then the same for the tenant. The tenant, in coming into that business, they have to also consider, are they going to do the build out by obtaining other private funds in order to do the build out?
Right.
Are there certain rules and things that they have to follow? Because if it's just a very weird time. It's legal under the state law and not under the federal.
Right.
So you're kind of restricted in the movements that you can make in running what should be a normal business now. So when we're looking at the lease, just like with any other business lease, you want to make sure that if you're not able to get the approved use for what you want to do, you want to be able to have an exit clause out of that lease. So for example, if I find a space and I talk to the landlord says, yeah, this is a perfect space for this type of use. Well, the landlord is not the one that ultimately approves it. We got to go to the local municipality, we got to go to the state. So if I end up getting denied, I want to make sure as a tenant that I can get out of that lease without having to be on the hook for whatever my remaining terms are for those damages.
Right.
So that's one consideration. The other consideration is if I'm spending a significant amount of money doing the build out and making that place look like I need it to be for my business, and for whatever reason I leave or I close down, do I get to take that stuff with me?
Oh, that's a good call. Yeah, it's something I hadn't thought about before.
Yeah, so that's another consideration to have. And from the landlord's perspective, if they're the ones ending up buying the property and they're going to also be the ones operating the business, as you know, with certain laws that do not allow the landlord to deduct ordinary expenses, or the tenants would, it determines on how you want to structure the lease. Is it a gross lease, which means the tenant pays a fixed amount inclusive of all the costs that the landlord incurs in maintaining the space and getting insurance and paying property taxes? Or is it going to be a triple net lease where you have the tenant reimbursing the landlord for all of those things? Well, if you're both the landlord and the tenant, you want to go with the best option that allows you to get the best tax benefits.
Right.
And so it's kind of like playing chess when you think of a lease. You can make so many different moves, but you need to know where you want to get to figure out where you're going to go.
Right. So another thing that you want to think about when you're trying to decide, should I own, should I lease, how should I do this? If you're going to be leasing property, keep in mind that your rent payments as a marijuana business are not deductible on your taxes under Section 280E of the Internal Revenue Code. So Section 280E, I know you guys have heard me talk about it in the past. It basically says that you can't deduct any normal business deductions on your taxes except for the cost of goods sold if you're in the business of manufacturing, selling any sort of controlled substance or anything like that. Marijuana is still a controlled substance, so that unfortunately applies to us. So because rent is not part of the cost of goods sold, we can't deduct that. So if you're going to just go to a really fancy schmancy building and sign a lease for it, and your rent is through the roof, and you can't deduct that, you're going to take a significant hit on your overall net profits. And that's something that you're going to want to pay attention to when you're trying to decide, should I lease, should I own, how should I do this? You can also think about, if you decide to own, maybe it makes more sense for a holding company to own that real estate and then paper a lease to your marijuana business. So that protects the property from liability from people coming in to see, file a lawsuit against your marijuana company and trying to take the property away from you. So that protects you there, and it'll basically just kind of allow you to have more control over your real estate and how you have your business relationship between the landlord company and your tenant marijuana company. So these are all considerations that you're definitely going to want to explore with your attorney, with your CPA, with the other members in your business company, and really kind of hammer home before you make any snap judgment calls. I know it's really tempting when you see a brand new listing that pops up on, like some sort of real estate website or a new lease that is available, but you definitely want to think about the ramifications, like how to get out of a lease if that's the route you want to go. So I just kind of want to shift gears a little bit here, because I know that you've done a lot with liquor licensing in the past, and people always come to me and ask, is this similar to liquor licenses? Can I sell it, or can I transfer it just like a liquor license? What does this look like? And so can you kind of tell me a little bit about what the differences are, and if it's as easy as liquor or not as easy, and what your general thoughts are on that?
So just like the state of Michigan has a department called we call it LARA, Licensing and Regulatory Affairs, and it has a division called the Michigan Liquor Control Commission, just like how the LARA has the BMMR, which regulates the marijuana industry. So in that regard, you're dealing with two departments that are run by the state. The application, both of them have applications that you apply for. Obviously, the requirements for each are different. But the most interesting thing that I'm seeing right now is the dynamics in how the license is given, right, and then how the license can be treated. And I'll tell you exactly what I mean. For example, with liquor, if I want to go and open up a restaurant, I don't have to build the entire restaurant to how I want it to look if I need to submit an application to the state to get approved. My understanding from marijuana is you actually, in order to get approved, you have to build out the place according to the specifications, that you've submitted to the state for the layout. So they have to come and make sure that, hey, everything that you put on this paper that this is going to look like, it has to look like it before they give you your approval. Yeah. With liquor, it's not like that. You give your plans, and yes, you better make sure that once they issue you your approval, which means you look good on paper, they will not issue you your final license to do business till they come out, check everything out, make sure everything is good, and then they will issue you your license. Okay. So I found that to be very interesting because, again, keep that in mind. That's a big risk that many people may not have known. You have to spend a lot more money investing in a license that you may or may not get. Right. And that's a risk that you have to assess if you can afford to take. Absolutely. So that's one of I think the major differences between those two, and obviously the regulations are still developing. Recently, if anybody wasn't approved by a certain date, they had to close down. Right. And then all of a sudden that kind of changed again, and then people could reopen, or where you get your product from, and then there's recalls. So the industry is still trying to figure itself out, which I think is all the more reason why you need to make sure that you have a good support staff with you and you're educated about it, because you may not know what was okay to do yesterday is not okay to do today. And if you have a license, you're jeopardizing that. Right. Another consideration that's different between the two is how you transfer ownership, which you said yesterday, was it that they actually approved the change of ownership?
They did. Yeah, the first one ever in Michigan, which is very exciting.
So what happened is somebody gave some of their percentage to somebody else, and they bought in and approved that person as part of the company?
Right. They approved the transfer. So somebody had a buyer lined up to purchase 25% of the membership interest. And in order to finalize this transaction, they have to be fully vetted by the state and approved by the board. So there's really no documents that have been released by the state, to my knowledge, for this, but I believe it's just an ongoing conversation with the department to help effectuate this transfer. And once the board had reviewed the materials, they were able to vote on it, and it passed without a whole lot of conversation, but it still passed. So it's the first of hopefully many.
This is very, very, very important, especially from a transactional standpoint, because this is telling you that you cannot pay for or you cannot buy anybody else's interest in a company until the state gives you that golden seal and approval to now do it.
Right.
So when you want to come in and you say, okay, I'm interested in buying this person's shares, it can't happen within as fast as the time as it takes for us to draft those documents. You have to wait in order to get their blessing before there's a change in ownership. And that's different than a lot of other licenses that the state of Michigan has. So this is also something that's very different. And in some situations, just from representing a couple of municipalities before, some cities do require you to tell them if there is any change, and some define what significant change of ownership is and some don't, which means, you know, if you're giving 1, 2, up to 10%, sometimes that's minority interest in the company. Some say if it's over 50 or 51%, you have to let us know. So you need to check with your municipality. And sometimes in the leases, I know in the ones that we've drafted, if we're the landlord and we're letting a tenant come in here and this is a new company that they just formed and the company doesn't really hasn't done business, we're giving that lease based on the person that we're dealing with that runs the company. If they're going to end up going and transferring substantially all of their interest in the company or a majority, and they're not the person in control of the company anymore, you may have to notify your landlord of that.
Right. Yeah.
So it's like a domino effect. One thing kind of leads to the other, and everything has to be timed properly, and you don't want to be putting out fires after everything is done. That's not good business.
It's not good business, and I know it's enough to give anybody a headache, but this is what happens when you have a highly regulated industry and you're trying to develop new businesses. So we have business law considerations. We have a new gray area industry where we're legal under the state law, we're illegal under federal law, and we're trying to mesh both of them to work in harmony. So there's a lot going on. I know that we threw a lot at you on today's live show. However, this will be available by posting on our YouTube channel. So if you missed something or you weren't sure, feel free just to check it out. You can rewind, you can fast forward on YouTube. Also, feel free to just comment on the Facebook post, and we'll be happy to answer any questions you may have, because I know there was a lot of really technical information in this video that maybe didn't quite make a lot of sense. So that's totally okay, and feel free just to make those comments. As always, it's a pleasure. Thank you so much for joining us today. I'm Jennifer Domingue, and of Counsel, Salam, Elia, signing off.